Death is something we all have to face eventually. And while it's important to prepare for it emotionally and spiritually, it's equally crucial to understand the financial side of things, particularly concerning debt. Our debt doesn't simply vanish into thin air when we pass away. As grim as it may sound, many people carry a heavy load of financial responsibilities when they leave this world. And questions surrounding what happens to that debt posthumously can be perplexing. In this blog post, we'll delve into the complicated relationship between death and debt, discuss how it is handled in various circumstances, and share insights that could help you prepare for the inevitable in a more informed manner. The basics. What happens to debt after death? When we kick the bucket, our debts don't just die with us. Instead, they become part of what's known as our estate. Basically, everything we owned at the time of our death. Here's the kicker. The estate is responsible for settling debts before any assets can be distributed to heirs or beneficiaries. Any outstanding obligations, ranging from credit card balances, personal loans, car loans, and mortgages, have to be handled first. But how does that happen? It usually involves a legal process called probate. During probate, the decedent's assets, which can include money in bank accounts, properties, vehicles, etc., are identified and valued. A person, often called an executor, is appointed to manage the estate and settle debts according to state laws. Secured versus unsecured debt. Not all debts are created equal. There are two main categories: secured and unsecured debts, and understanding the difference is critical when it comes to what happens after someone dies. 1. Secured debt. This type of debt is tied to an asset. For instance, a mortgage is secured by a home, and car loans are secured by the vehicle itself. If the maker of the loan dies, the lender can reclaim the asset to cover the debt. So if someone defaults on their car loan after they pass, the lender can repossess the car. 2. Unsecured debt. This includes debts like credit card bills, personal loans, and medical bills. For unsecured debts, the process can get a bit trickier. The estate will pay off these debts if enough assets are available. If the estate doesn't have sufficient assets, the debts won't be passed on to family members or heirs. However, creditors usually won't get paid if there isn't enough money left over after settling secured debts. State laws and executor responsibilities. Every state has its own set of laws governing the handling of an estate after someone passes away, especially when it comes to debt. Executors have a fiduciary duty to settle debts in accordance with state laws, ensuring that they adhere to proper protocols and pay creditors fairly. This means they have to notify known creditors of the individual's death and manage claims against the estate. But what if the estate is insolvent, meaning its debts exceed its assets? In that case, the executor may have to negotiate with creditors or choose which debts to pay based on priority. Secured debts often take precedence. Spouse and co-signer responsibilities. Many people worry that their spouse or family will inherit their debts upon death. While it's mostly true that debt doesn't automatically get passed on to family members, there are some exceptions. 1. Joint accounts. If you and your spouse have joint debts, both individuals remain responsible, even after death. For example, let's say both partners took out a credit card together. When one partner dies, the surviving partner is still responsible for the outstanding balance. 2. Community property states. In some states, known as community property states, debts incurred during the marriage are considered joint responsibility. This means your spouse might be liable for certain debts even if they were solely in your name. Handling debt. Postmortem. Creditors and collections. Creditors may be less likely to pursue family members for the deceased's debts unless there's joint liability. However, this doesn't mean you won't hear from collection agencies. They may try to contact family members, but it's important to remember that under the Fair Debt Collection Practices Act, they are not allowed to harass or bully you into paying debts that aren't your responsibility. In certain situations, it might be necessary to speak with a legal professional who specializes in estate planning or probate law, particularly if you're dealing with complex debts or a challenging family dynamic. What about student loans? Student loans can add an additional layer of complexity when it comes to the conversation around debt after death. Federal student loans are generally discharged upon the borrower's death, meaning the debt disappears and doesn't get passed on to heirs. However, private student loans can be a different story. Depending on the terms of the loan and the lender's policies, heirs may be responsible for repaying those loans. Estate planning. Preparing for the inevitable. While we can't control when our number will be up, we can control the impact of our financial decisions on loved ones left behind. Estate planning is an essential part of preparing for the future, as it addresses how your debts and assets will be managed after your passing. Here are some concepts to consider. 1. Creating a will. A solid will is crucial. It outlines how you want your estate to be managed and provides guidance to your executor. It's essential for reducing ambiguity and ensuring a smoother process during probate. 2. Establishing a trust. Trusts can help protect your assets and simplify the process of passing them on to heirs. They can also minimize tax consequences and potential probate challenges. 3. Discussing finances with family. While it may be uncomfortable, having open conversations with family members about debts and financial matters is crucial. It can demystify the process and help prepare them for what to expect. 4. Insurance considerations. Some people opt to take out life insurance policies to cover potential debts after their death. This can be a strategy to ensure that their family isn't burdened with financial stress. Final thoughts. Navigating a difficult topic. It's easy to brush aside discussions about death, especially when it involves the financial aspects of our lives. The reality is that understanding what happens to your debt when you die is a crucial part of prudent financial planning. Nobody likes to think about what happens after they're gone, but having a solid grasp on the potential impact on your loved ones can help make the situation a little less daunting. Preparation and planning can form a safety net, minimizing the burden on those you leave behind. If anything, use this guide as a stepping stone for those often avoidable yet necessary conversations about money, assets, and responsibilities. The more we talk about these topics, the more we demystify fear and uncertainty. And wouldn't that be a worthy conversation to be had? As with all financial matters, don't hesitate to consult with a financial advisor or an estate planning attorney to ensure you're making informed choices that align with your specific needs and circumstances. After all, it's better to leave behind a legacy of love and care rather than unanswered questions and mounting debt. Life is too precious to worry about what comes next. So go ahead, make those plans and keep building your legacy.